Good afternoon and salam sejahtera, Dr. Saiful. I'm Loh Jun Quan, metric number 262260. So we are from group 5 and our group consists of 5 members, which are Xiang Yu, Nurul, Aqilah, Faezatul, Azlin, and me. So today we are going to present the outcomes for the case or trade dispute between the Inter-Heritage Sdn Bhd, the Sheraton Imperial Kuala Lumpur Hotel, and the National Unions of Hotel, Bar, Restaurant Workers, Peninsula, Malaysia.
Assalamualaikum and good day to Doctor and all my classmates. My name is Faezatul Binti Kasim, matrix number 269851. Today I'm going to present for part 1 and part 2 for this group assignment. Part 1 involves case situation. Firstly, in this case, parties involved is Inter-Heritage Sdn Bhd versus National Union of Hotel, Bar and Restaurant Workers Peninsula Malaysia. Then, the case status. The case was in Industrial Court Malaysia, Kuala Lumpur and closed on 13th July 2018. Next, the issue that led to the dispute in this case is following the implementation or introduction of the Minimum Wages Order 2012, the hotel restructured the employees' wages by converting service charge into basic salary to meet the minimum wages of RM 900 per month without the consent of union. Then location of the organization is Sheraton Imperial Kuala Lumpur Hotel. And lastly, date of the case is on 8th May 2014. Okay, now we will proceed to the issues to be addressed in this case. Whether the hotel is entitled to restructure the employees' wages in response to the implementation of the Minimum Wages Order 2012, which involved converting part or all of the service charge payable to be included with the basic wages to form the minimum wages RM 900 ringgit per month. That's all from me. Thank you.
Hi and Assalamualaikum to Doctor. My name is Nurul binti Lockman Hakim and my metric number is 26952. So for today, I would like to continue presenting about the issue for the employee or union. So the first issue regarding to the employee or union is the wages restructuring by hotel does not violate to the collective agreement CA. If we refer to the CA in the case, both parties are agreed that in addition to the basic salary paid under the salary structure, the hotel shall distribute 90% of the service charge to all eligible employees. The hotel also stated that the new wage structure has added to the agreement that contribute 90% of the service. As well, union had no objection to the guideline issued by NWCC. If you refer to paragraph 3 of the guideline on the implementation of the Minimum Wages Order 2012, it allows the employer to convert all or part of the service charge to form part of the minimum wages. So in this issue, we can see that the union feels so dissatisfied with the hotel about the overall information and detail stated by the hotel. The next issue is the hotel claim they are restructuring of the employees' wages with fair, reasonable, and equitable prices. The hotel stated that they has no less favorable wages in the event of wages restructuring, as well no reduction in amount of the employee's earning. If we refer to the case, the employer stated that the hotel employee stated that the hotel pays employee with an unreasonable salary without unlogical mathematical calculation. So through this issue, it caused dissatisfaction of the employee to the hotel with their respect about the salary claim. So the last issue is the implementation of service charge. If we know, Malaysia implemented and practiced a tipping system and currently has been replaced by a service charge. Due to the incident, the employee was dissatisfied because service charge should be considered as payment for work done in connection with the worker's contract of service. So, the employee feel it not appropriate for the hotel to take advantage of the manpower related to the service charge in order to make more profit to the hotel side. So that's all for me.
Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. My name is Azlin binti Zulkifli and my metric number is 269985. So proceed with the issues for the employer or management in the hotel. Basically, there are 4 issues that could be identified or highlighted among the employer or management in the hotel. So first of all, contradict the National Wages Consultative Council Act 2011 and Minimum Wages Order 2012. For our information, National Wages Consultative Council Act 2011 has responsibilities to conduct studies on all matters regarding the minimum wages and to make recommendations to the government to make minimum wages orders according to the sectors, types of employment, regional areas, as well as provide for related matters. In this case, the inclusion of service charge to form minimum wages do not promote and align with the objective of National Wages Consultative Council Act 2011 and Minimum Wages Order 2012. So this can be proven when the union contended that the wages restructuring decision was essentially a mathematical calculation that did not comply with the Act. Second, breach of collective agreement. The proposal of wages restructuring was rejected by the union on 1st October 2013. So the hotel unilaterally implemented the wages restructuring practice without the consent of the union. This can be proven when the new wages structure that includes a service charge as an integral part of the wages to meet the minimum wages was improper, as the proposal have been rejected during the negotiations for the renewal of the collective agreement. Third, unfair and inappropriate wages practice. In this case, for our information, the hotel was introduced a new service charge system to replace the tipping system in ensuring the fair distribution of the collected funds. The service charge will be paid by the customers while the hotel acts as an agent to distribute the service charge equally to the eligible workers based on the agreed percentage. We should know that the inclusion of the service charge to form the minimum wages absolutely will detriment the workers' benefit. This is because the service charge should be excluded from the minimum wages as it is not related to the hotel earnings. So hotels should use their own funds in order to form the minimum wages of RM 900 instead of recourse to the service charge. The last one is hotel suffer a great financial burden and losses. In this case, the hotel literally face or receive adverse impact, especially in terms of financial ability and competitive level of the hotel, which drive a significant rise in manpower costs. According to the hotel capacity, if the hotel is not entitled to restructure wages by converting part of the whole of the service charge payable to comply with the minimum wages order 2012, the hotel is forced to bear an additional cost around RM 107,189 and 83 cents to meet the minimum wages of RM 900 every month.
Okay, now I'm going to present the findings of the case. So in overall, we decided that the hotel reserved the right and be entitled to restructure the wages by converting part or the whole of service charge payable to comply with the minimum wages order 2012. So before we go further to reasoning, so these are the act or courts that we refer to. So first, the Section 2 of National Wages Consultative Council Act 2011 define wages has the same meaning assigned to it in Section 2 of the Employment Act 1955 and define minimum wages as the basic wages. So second, in Section 2 of Employment Act 1955, the wages is defined as the basic wages and all other payments in cash payable to an employee for the work done in respect of his contract of service, but does not include the value of house accommodations or the supply of any foods, fuel, light, waters, or medical attendance, contribution paid, traveling allowance, payments for the defray spatial expenses, gratuity payable, and annual bonus. So next, we also refer to the industrial Industrial Relation Act 1967. So under Section 30, Paragraph 4, so in making any awards in respect of the trade dispute, we should consider the public interest, the financial implication, and the effect of the awards on the economic and industry. So also under Section 30, Paragraph 5A, so in making it awards, so the court may take into the consideration of any agreements or courts relating to the employment. So beside paragraph 3V of the guidelines on the implementation of minimum wages order 2012 mentioned that the hotel sector where the service charge collection is implemented, the employer may convert all or part of the service charge means for distributions to the employees to form part of the minimum wages. So also we refer to the Code 1 of Code of Conduct for Industrial Harmony 1957, where the trade unions should ensure that the policies and practice that they adopt are not only fair in relation to the function and purpose for which they have been formed, but also take into the consideration of the national interest. So lastly, the Order 6 of Minimum Wages Order 2012 allowed the employer before the implementation of minimum wages order to negotiate on the restructuring of wages in respect of the following condition, in which the restructuring wages should be in accordance with the minimum wages rate and should not be less favorable than the employee's existing wages and should not be less than the amount of the wages earned by the employees before restructuring of wages and only involve the payment for work done and should not cause the employees to lose any remuneration. So these are the act or codes that we refer in making the resolution. So now we are going to see the reasoning of the decision. So first, the inclusion of service charge to form minimum wages in hotel is reasonable. So the hotel introduced the service charge system to replace the tipping system to ensure a fair distribution of the collected funds amongst employees by charging a fixed service charge rate from the hotel customers. So according to the National Unions of Hotel Bar Restaurant Workers versus the Seaview Hotel Pulau Pangkor 1980, so the reason why the wages of employees in hotel industry is low is because they are entitled to receive the service charge. So the service charge was to buffer the low basic salary. So the court held that the salary of employees was comprised of basic salary and service charge. So in addition, so the Section 2 of National Wages Consultative Council Act 2011 did not define the terms basic wages, so and did not state which components should be included in basic wages. So also Section 2 of Employment Act 1955 did not state that the service charge was excluded as part of wages. Therefore, the wages should be comprised of basic salary and service charge. So moreover, refer to Pa Pereira and No versus Hotel Jayapuri Berhad. So the Privy Council held that the employee is liable to make the monthly contribution to the EPF based on the total amount of basic salary, which include the service charge. So also in the case of the National Unions of Hotel Bar and the Restaurant Workers Peninsular Malaysia versus Masyo Mutiara Sendirian Berhad 2014. So the Court of Appeal held that the service charge payment should be taken into account for paying the retirement benefits. And additions, so both findings of the Port Reef Seafood Village Sendirian Berhad versus the Roslyn Tuber Redness 2011 and the Decor Wood Industry Terengganu Sendirian Berhad versus Timber Employees Unions indicated that the service charge is the payment for work done, so which directly related and connected to the performed works under their contract of service. So obviously, according to the decided cases, so the union has successfully advocate that the service charge was a payment paid for the work done under the contract of service or the contract of employment. So the decided case determined that the service charge should be included in the computation of overtimes, retirement benefits, retrenchment benefits, and etc. for the employees in the hotel industry. So thus, the service charge should be taken as a part of minimum wages to comply with the requirement of minimum wages 2012. So next, the wages restructuring practice does not violate the terms of collective agreements as there is no objection from the union on the issuance of the guidelines on the implementation of minimum wages order 2012. So also the collective agreement does not outline whether the service charge should or should not be included to form the minimum wages. So in the new wages structure, so the hotel remained the agreed distribution rate of the service charge to the employees. So there was no reduction to the distribution of 19% of the service charge as agreed in the first collective agreement with the unions. So in short, the wage restructuring practice did not breach the terms of the collective agreement. So, moreover, the wage restructuring practice comply with the method of restructuring wages. So, as referred to the Order 6 Minimum Wages Order 2012, so the restructuring practice of the hotel is no less favorable than the employees' existing wages, where the employees who earn more than 900 ringgit will receive the same amount of wages, well, the employees who earn less than 900 will enjoy an increment under the minimum wages order 2012. So the restructuring of wages only involve the payments for work done during the normal hours of work of the employees, so which comprise the basic wages and the service charge. So the employees would not be in a worse off position, and after the restructuring exercise or practice, the employees could enjoy a higher contribution to SOCSO, to the EPF, and the overtime payments. So obviously, the hotel fulfill or fully comply with the condition of restructuring wages under the Order 6 of the Minimum Wages Order 2012. So that's all from me. So Xiang Yu will continue the rest of the reasoning part. So thank you.
Hello everyone, my name is Xiang Yu. My matrix number is 265348. My part is reasoning part 4 and 5. The wage restructuring practice should consider financial implications and the effect of the award on the economy. Section 13. 4 of Industry Relations Act IRA 1967 consider the public interest, the financial implications, and the effect of the award on the economy and industry. The exclusion of the staff change may ruin the remuneration system. Junior reserveship increment as compared to senior. Financial burden for hotel. Hotel suffered consecutive losses in the from 2013 to 2015. Gross operating profit (GOP) experienced downward trend, affect the economy and tourism industry of Malaysia negatively. Missing Omnibus Code SDM BHD V Kesatuan Pekerja Pengangkutan Semenanjung Malaysia Anno 1998. The chart allows the hotel to convert part or all of the staff change to from part of minimum words. Next, part 5. Promote industrial harmony according to Section 13(5)(a) of IRA 1967, Code 1 of Code of Conduct for Industrial Harmony 1957, in order to achieve industrial harmony and win-win situation for both hotel and union countries' economic and social development. The hotel shall be entitled to restructure which is by converting percentage 19 of the serve change to comply with the M1WO 2012. Merging Omnibus Code SDN BHD V Kesatuan Pekerja Pengangkutan Semenanjung Malaysia and Endo. Okay, thank you. Alright.